Well, college admissions are officially changed for good. The Supreme Court has just ruled that race-conscious admissions are unlawful. What happened and what does it mean? We're going to try and break it down in 5 minutes. Hey everybody, I'm Isaac Saul and welcome to the Tangle YouTube channel. Today, we're going to be breaking down the affirmative action Supreme Court ruling that just came down. We're going to explain what the left is saying, what the right is saying, and of course, as always, I'll give you my take. First though, we're going to start off with the basics. There were 2 cases before the Supreme Court, basically in conjunction. One of them was against Harvard University and alleged that Harvard was violating Title VI of the Civil Rights Act, a law that bars entities receiving federal funds from racial discrimination. The second was a case against the University of North Carolina, arguing that it was violating the 14th Amendment's Equal Protection Clause. That's a clause that bars racial discrimination by government entities. North Carolina, like many schools, was considering race in its admissions in order to create a more diverse student body. On Thursday, the court declared that race-conscious admissions violated both the 14th Amendment's Equal Protection Clause and violated Title VI of the Civil Rights Act. It was a 6-3 ruling with all 6 conservative justices in the majority and all 3 liberal justices in the minority. It's worth noting here that race-conscious admissions have been challenged for some time. Through a series of rulings that started in the 1970s, the Supreme Court has said that race can be considered in its admissions process if a school was hoping to create a more diverse student body, though past rulings have presumed that at some point affirmative action would end. The justification has not just been a kind of reparations, that minorities were excluded from educational opportunities and this was a way to balance it. But many schools were also arguing that a more diverse student body equaled more diverse perspectives, which equaled a better education environment for students. And colleges said, we have a right to pursue that better education environment.
The Supreme Court's decision on college and university admissions will change how we pursue the educational benefits of diversity. But our commitment to that work remains steadfast. It's essential to who we are and the mission that we are here to advance. For nearly 9 years, Harvard vigorously defended our admissions process and our belief that we all benefit from learning, living, and working alongside people of different backgrounds and experiences.
However, opponents of affirmative action have argued that admissions to elite universities are a zero-sum game, and affirmative action is a kind of reverse discrimination that is both unconstitutional and negatively impacts some minorities. For instance, data produced in arguments from the Harvard admissions case has shown that African American students in the 40th percentile of their academic index are more likely to get into Harvard than an Asian student in the 100th percentile. Given this huge disadvantage to Asian American students, opponents have argued that this amounts to unlawful racial discrimination. The court's ruling against affirmative action means that some of the most prestigious universities in the country will no longer be allowed to emphasize race in their admissions process. Crucially, Chief Justice John Roberts did leave one carve-out for universities to still consider race in some ways. For instance, he said a student could write about their experience as a racial minority in a cover letter, and a university could consider that personal experience and how it shapes the student. Then they can decide if they want this student as a part of their student body. For whatever it's worth, a 2019 Pew Research poll found that 73% of all Americans, including 62% of Black Americans and 65% of Hispanic Americans, did not think that college should be able to consider an applicant's race or ethnicity when making decisions about student admissions. So, what are both sides saying about this? We're going to jump in with the right's take first. On the whole, the right is supportive of this decision. Many believe the argument is overwhelming that Harvard discriminated against Asian applicants, and the simple case is that there is no American population that should face discrimination because of their race. Some conservatives also cheered Roberts for emphasizing that a student can tell the story of their race by telling the story of their experiences. In other words, considering a student must be focused on who they are as a person, not what their skin color is. Further, some point out that even if you are accepting the premise of race-based admissions, Black students who actually descended from slavery are often not the ones who benefit most from these programs at elite schools. Indeed, at Harvard, more than 2/3 of the Black students were West Indian or African immigrants coming from affluent families. Some cheered the court for firmly noting that these admissions processes violate the Equal Protection Clause of the 14th Amendment. This was supposed to be a 5-minute video. I don't think that's happening. But as Roberts put it in his majority opinion, quote, both programs lack sufficiently focused and measurable objectives warranting the use of race, unavoidably employ race in a negative manner, involve racial stereotyping, and lack meaningful endpoints. We have never permitted admissions programs to work in that way, and we will not do so today, end quote. Conservative columnist Ben Shapiro offered this analogy on Twitter. He said, imagine that Major League Baseball broke the color line by recruiting the best players from the Negro Leagues, but instead they changed the rules of the game so black pitchers would only need, say, 2 strikes to get a batter out. Everyone would recognize this as something that makes baseball worse, that makes black players worse, and exacerbates racial tensions. Race-based admissions are no different, according to Shapiro. He said, quote, the only way to remedy past discrimination is not present discrimination. It never was. So that's the gist of the right's argument. And before we jump into the left's argument, I want to remind you that if you are getting anything out of this channel, please press subscribe, like this video, leave a comment. All that kind of engagement tells the YouTube algorithm that you like what we're putting out, and it'll help get Tangle in front of some other people. All right, so what is the left saying about this case? Well, the left, as you might not be surprised to hear, is strongly opposed to this ruling. There are a few basic reasons why. For one, there's the fact that we are still attempting to right some wrongs from the past. Inequality in education is not simply over, nor is racial discrimination. Affirmative action is a way for schools to open new doors for minorities, make their campuses more diverse, and create more just outcomes on the other side of college. Further, there are things about this legal argument that the right often leaves out. For instance, Justice Sonia Sotomayor argued clearly that the 14th Amendment was designed to combat inequality, and authors of that 14th Amendment understood it would be used for things like affirmative action. Indeed, affirmative action was used in the lifetime of the people who authored that amendment, and pretending it offends the amendment they drafted is absurd, in her opinion. Others suggest that the Supreme Court is ignoring the leaders of these prestigious institutions who know how to best create a good educational environment. As Ian Millhiser put it in Vox, generals and admirals have warned that less diverse campuses mean a less secure nation, while medical experts say diverse campuses will reduce deaths, while America's most successful companies say diversity helps American companies stay dominant. Millhiser said the Supreme Court is taking one hell of a gamble by assuming that it knows better than these leaders. The New York Times editorial board bemoaned the end of a system that has provided decades of opportunity for thousands of students who would have otherwise been turned away. In states where affirmative action has been banned, black enrollment in college is already falling. This imperfect system was designed to expand the rights of Americans who had suffered under a legal system that treated them as second-class citizens, and we're ending that system while this inequality endures. Finally, a lot of folks on the left are just pointing out that affirmative action was just one other way that admissions processes weigh students. For instance, legacy admissions allow the children of past students to get a leg up. Donors' kids often get into colleges they shouldn't. Athletes get into elite schools for being able to shoot a basketball. Why shouldn't diversity be weighed when building a student body? All right, that is it for what the left and the right are saying, which brings us to my take. Before we jump in, I just want to remind those of you, if this is your first time watching a Tangle YouTube video, my take is not meant to be the final word on this issue. It's just a way for me to be transparent about my view. You can take it or leave it, and if you disagree, please leave a thought in the comment and we'll try and address it in next week's video. So we wrote about this case after oral arguments, and my position has basically not changed since then. It went something like this. First of all, affirmative action was justified. I absolutely believe that it was a well-intentioned, smart policy to try and balance the scales of justice after decades of excluding minorities from higher education opportunities. I also believe fundamentally that diversity on campus, not just racial, but economic, political, etc., is a great thing for colleges to strive for. Lyndon Johnson's famous quote says it all.
You do not take a person who for years has been hobbled by chains and liberating, bringing up to the starting line of a race, and then say, you are free to compete with all the others, and still justly believe that you have been completely fair. Thus, it is not enough just to open the gates of opportunity. All our citizens must have the ability to walk through those gates.
I also do not think prohibiting consideration of race is the right call or legally justified. The court has gone pretty far here, but Roberts' language about allowing students to share their experiences as racial minorities for colleges to be able to consider that was an important and right decision. Some students' racial background is critical to who they are and what they've been through, and colleges should be able to consider it. But it's also true that race-based admissions has become extremely convoluted and a form of negative prejudice on its own. The data on Harvard and the experience of Asian Americans is damning. This trap of race-conscious admissions was always obvious as affirmative action policies achieve their goals, which in many ways, they actually have. We do have more diverse colleges today than we used to, and we have a lot more opportunity for minorities at the university level today in America. On the legal merits, I have a hard time deciding where I land. It is simply ahistorical to pretend that race-based admissions were not considered in the 14th Amendment. They were. There was also decades of precedent on the side of the universities here, but there seems to be no way around the fact that race cannot exclude certain people from college campuses, and in these cases, the plaintiffs made it pretty clear that it was. At the same time, as Ketanji Brown Jackson herself argued, if you're going to include legacy status in admissions, then you are de facto including race, since so many colleges have a legacy of not including people because of their race. More to the point, though, the whole idea of affirmative action is no longer an effective way to solve the problems that plague elite colleges. It's the exclusiveness that creates the issue. When your entire application pool are perfect students with perfect scores and perfect backgrounds, guess what? You start making decisions based on things like race. If these schools want to solve the problem, they should just expand their student body. That's the solution here. It's not figuring out what to do about affirmative action. In my perfect world, colleges would focus primarily on things like wealth and income status when considering which students they want to reach out to in order to diversify their student body. Race, immigration status, language use, political diversity, all those things could play secondary roles. If you want a diverse student body and an exciting learning environment, that is how I think colleges should do it. But unfortunately, that perfect seems nowhere near happening. All right, before you guys get out of here, please don't forget, we want to hear your thoughts. I'm sure a lot of people have strong feelings about this, so leave a comment in the comment section. Let us know what you think, how you view this case. And of course, don't forget to hit subscribe, like this video, and spread the word about our YouTube channel before you get out of here. Thanks for watching. Peace. Get in here. We'll put you on the channel, man. It's my wife's brother, my brother-in-law.
Big Tangle fan.
Yeah. Affirmative action is no longer an effective. All right, here we go. I'm unraveling.